I feel like you probably spend your entire life just clicking I agree.
Oh, absolutely. Every single day.
Right. Like you update the software on your phone, and this little box pops up with, I don't know, 80 pages of dense, completely unreadable text.
And no one reads it. You just blindly tap the button at the bottom so you can get back to your text messaging.
Exactly. Or, you start a new job, and on the very first day, Human Resources hands you a stack of paperwork that's like as thick as a phone book.
Oh, yeah, the onboarding package.
Yeah. And you just sign on the dotted line 20 different times without really thinking about it. Because, well, we live our lives making this fundamental assumption.
Which is,
We expect a contract to be like a blueprint for a house. Like every wall, every door, every window is rigidly defined on that paper before you ever pick up a hammer.
that's a great way to put it. We assume that if it's written on the blueprint, it's just an undeniable fact.
Right. But what if that blueprint doesn't actually matter?
That's the terrifying part.
Seriously. Like, what if you build the house completely differently than the drawing, and the law actually decides to look at the physical house, not the paper?
It's a very comforting illusion, that blueprint idea. We crave that certainty.
We really do.
We want to believe that the ink on the page represents this impenetrable shield. So if a dispute ever arises, we want to be able to just point to paragraph 4, subsection B, and say, look, it's right there in black and white.
But we are looking at a modern legal landscape where that blueprint is, frankly, routinely ignored.
Completely ignored in some cases.
Like, what if a judge is willing to look at your signature, tear that meticulously drafted document in half, and just tell you it is completely meaningless?
Well, that is the terrifying and, frankly, fascinating reality of modern contract law.
Yeah.
We are actually moving from a world that, worships the form of a document to a world that ruthlessly examines the substance of human behavior.
Which is exactly what we're getting into today. You are listening to our deep dive into the hidden legal mechanisms that govern your life.
And it really touches everything.
It really does. Whether you are, prepping for a massive corporate negotiation, or you're just trying to understand your rights at your side hustle, or maybe you're just insanely curious about the invisible rules of society, you are in the right place.
Absolutely.
Today, we are taking a massive stack of research and just distilling it down to the essentials. We're building this entire conversation on 2 incredibly revealing sources.
Right. The 2 documents.
Yeah. First, we have this heavy-duty, very pragmatic legal framework paper titled Beyond the Document. And this paper looks at how landmark, like earth-shattering court cases, have just completely destroyed the facade of written contracts.
It's a fantastic paper.
And second, we are pairing that with a meticulous critical analysis report by M. Usman Ali Khan.
Which is brilliant. He takes a legal infographic that was designed for the general public and just completely dissects it.
Yeah, he shows us exactly where our basic assumptions about the law go terribly, terribly wrong. So our mission today is to give you a new set of eyes.
Yes, a totally new perspective.
By the time we wrap up this deep dive, you're going to be able to spot exactly when an offhand marketing promise becomes a legally binding trap.
And perhaps more importantly, you'll understand exactly when a meticulously signed legal document isn't worth the paper it is printed on.
Right. But, to understand how easily you can accidentally blind yourself to the law without ever picking up a pen, we actually have to travel back in time a bit.
We do. We need to leave the era of digital terms and conditions, put down our smartphones, and just head back to the late 19th century.
It is kind of the perfect starting point, right?
Yeah.
The foundation of our hyper-modern digital commerce was actually laid down by, of all things, a bizarre flu remedy.
A flu remedy, a terrifying global pandemic, and a very, very stubborn woman in London.
Yes. The legendary case of Carlyle v. Carbolic Smokeball Company.
Decided in 1893.
Right. And to really grasp why this case changed the world, we have to set the scene. It's 1889, and the Russian flu is just sweeping across the globe.
And this was a brutal pandemic. Over 1 million people died worldwide.
Yeah, in London, people were absolutely terrified. I mean, the hospitals were overflowing, politicians were dying,
Right.
and there was just no cure.
And, well, you know how it is. Whenever there is mass panic, there is an opportunistic market.
Yeah, for sure.
Companies were rushing out every conceivable potion, powder, and gadget, just claiming it could ward off the influenza.
Enter the Carbolic Smokeball Company.
Right.
They invent this contraption. And I really want you to picture this,
Yeah.
because it is not a pill. It's not a pleasant syrup.
Not at all.
It was a hollow rubber ball attached to a metal tube. And inside the ball was carbolic acid powder.
Which, by the way, was a chemical commonly used to disinfect raw sewage.
Which is insane. It's just
Yeah.
a rather harsh chemical, to say the least.
Definitely.
So the instructions told you to insert the metal tube into your nostril and squeeze the rubber ball.
Oh.
Yeah. It would shoot a cloud of stinging, burning carbolic acid powder right up your nose.
Ouch.
And they claimed that if you did this 3 times a day, it would create a protective barrier against the flu.
But of course, they had to convince people to actually buy this agonizing device.
Right, which couldn't have been easy.
No, they needed a marketing hook that really cut through all the other snake oil advertisements in the newspapers.
And they came up with an absolute masterclass in aggressive marketing.
Yeah.
They ran advertisements in major publications like the Pall Mall Gazette.
And the ad didn't just say, hey, this is a great product.
No, the text explicitly offered a reward. It said, and I'm paraphrasing the exact copy here, 100 pounds reward will be paid by the Carbolic Smokeball Company to any person who contracts the increasing epidemic influenza
Right.
after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball.
And just to put that into perspective, 100 pounds in the 1890s was roughly equivalent to a year's salary for a middle-class worker.
Wow.
Yeah, it was a massive, completely life-changing sum of money.
But the ad went even further than that. To prove they weren't just, making a hollow boast, the ad stated that 1,000 pounds is deposited with the Alliance Bank, showing our sincerity in the matter.
And that specific detail about the bank deposit is crucial, as we'll see when the lawyers get involved.
Right. So enter Mrs. Louisa Carlo. She is a reasonable woman just trying to navigate this terrifying pandemic.
Like anyone else.
She reads the advertisement, goes to the chemist, buys the smoke ball, and literally subjects herself to this horrific carbolic acid powder 3 times a day, every day.
From mid-November right through to January.
Yep. And guess what happens in January?
As she catches the flu.
She catches a severe case of the flu. So she recovers, and she does what any of us would do.
She asks for the money?
Exactly. She writes a letter to the company and says, "Excuse me, I followed your instructions. I got sick anyway, so I would like my 100 pounds, please."
And the company just ignores her?
Completely ignores her. So she gets her husband, who actually happened to be a solicitor, to write a formal legal letter.
That usually gets a response.
It did. The company finally responds and says, "You must be joking. We don't owe you anything. You didn't use it properly."
Ah, of course.
And besides, they said, "We require you to come to our offices and use the smoke ball in front of our secretary every day to prove you are actually doing it."
Which is just a classic tactic, right, to create these impossible post facto conditions to avoid paying out.
Exactly. But Mrs. Carlo refused to back down. She took them to court. And the company's primary defense has actually become one of the most famous phrases in legal history.
A mere puff.
Yes, they claim the advertisement was a mere puff.
It is a brilliant piece of legal terminology. They were arguing to the judge that the ad was just promotional hyperbole.
Right.
It was an exaggeration meant to attract attention, not a real binding legal offer. They basically said, come on, Your Honor, nobody actually thought we were serious. It's just advertising.
But you can't hold us legally accountable for being enthusiastic about our product.
Exactly.
Think about modern equivalents. Like Red Bull's old slogan, "Red Bull gives you wings." Obviously, you don't drink an energy drink and expect to, sprout feathers.
Right, that is a mere puff.
So the company was trying to say the 100-pound reward was the 1890s version of sprouting wings.
But the Court of Appeal fundamentally disagreed. And this is really where the tectonic plates of contract law violently shifted.
Yeah, they sided with Mrs. Carlo.
They did. The judges, specifically Lord Justice Bowen and Lord Justice Linley, looked at the specific phrasing of the ad.
And they pointed right to that sentence about the 1,000 pounds deposited in the Alliance Bank.
Exactly. They said, why would a company deposit 1,000 pounds in a bank to show their sincerity if it was just a joke?
Right. That specific quantified promise transformed it from a mere puff into a serious binding offer.
But this is the big question. How does a newspaper advertisement become a contract?
Which brings up the core concept our source document emphasizes,
Hmm.
the unilateral contract.
Yeah.
Before we go further, help us understand exactly what that means. Because I think most people assume a contract requires, 2 people sitting across desks from each other.
Let's draw a distinction here. The standard contract we all picture in our heads is a bilateral contract. Bi, meaning two.
Okay.
It is an exchange of mutual promises. I promise to pay you $5,000. You promise to paint my house. We negotiate, we agree on the terms, we make mutual commitments, And then we sign a paper before any actual painting begins.
Right. Both parties have an obligation. If I don't pay you, I breach the contract. If you don't paint the house, you breach the contract.
Exactly. A unilateral contract is an entirely different beast. Uni meaning one. It is an offer made by one party that demands a specific action rather than a return promise.
Okay, so the company making the offer promises to pay or provide something only in return for the successful performance of a specified act.
Right.
So the Carbolic Smokeball Company wasn't asking Mrs. Carlyle to, promise she would use the ball. They didn't want a letter of intent.
No, they just wanted her to physically do it.
That is the crux of it.
Acceptance of a unilateral contract does not require the person to communicate back to the offerer. Mrs. Carlyle didn't have to write a letter saying, "Dear Carbolic Smokeball Company, I formally accept your offer published in the Pall Mall Gazette and will now begin snorting your acid."
Thank goodness.
The law says the acceptance happens simultaneously with the performance of the act. Her acceptance of the contract was legally complete the exact moment she fulfilled the final conditions set out in the ad.
Which was catching the flu after using the ball for 2 weeks.
Exactly.
You know, it makes me think of an old Wild West bounty poster.
Oh, I like that.
Yeah, like the sheriff nails a poster to the wall of the saloon. Wanted, dead or alive, $5,000 reward for Black Bart.
Right.
The sheriff does not sit down in the saloon and negotiate terms with a bounty hunter. The bounty hunter doesn't send a telegram saying, "I accept your proposal."
No, they just go do it.
The bounty hunter just rides out into the desert. And the contract is instantly, irrevocably finalized the precise moment that bounty hunter kicks open the jailhouse door and drops Black Bart on the floor.
The performance of the action is the acceptance of the contract.
Yes.
That is an excellent analogy. The sheriff owes the money the millisecond the outlaw is delivered. And the Carbolic Smokeball Company owed Mrs. Carlyle the £100 the millisecond she contracted influenza.
But the company's lawyers were relentless, right? They tried one final desperate argument in court.
They did. They argued there was a lack of consideration.
Wait, consideration. We need to unpack that. Because if offer and acceptance are the first two ingredients of a contract, consideration is the third.
Right.
But if Mrs. Carlyle didn't pay the company directly for the advertisement, why did the court say the company got anything out of this arrangement?
Well, consideration is essentially the legal concept of value exchanged. For a contract to be binding, something of value must flow in both directions. The company argued, look, Mrs. Carlyle bought the smoke ball from a third-party pharmacy, not from us directly. And her using it at home doesn't give our corporate headquarters any direct, tangible benefit.
Because she did it for her own health.
Exactly. Therefore, they argued, there is no consideration and the contract is void.
They were trying to say it was just a one-way street, and the law doesn't enforce one-way promises.
But the judges completely dismantled that argument. Lord Justice Bowen reasoned that consideration can be either an advantage to the person making the offer or a detriment, like a burden or inconvenience suffered by the person accepting it.
Okay, so he pointed out two things.
He did. First, using this horrific contraption 3 times a day was a significant inconvenience and detriment to Mrs. Carlyle. She suffered to fulfill their conditions.
For sure.
Second, the company clearly benefited because the advertisement drove massive sales at those third-party pharmacies.
Right.
By using the ball, she was acting on the faith of their promise, fulfilling her end of the bargain. Consideration was firmly established.
So the company loses. Mrs. Carlyle gets her money. It is a fantastic piece of Victorian history. But why are we talking about it today?
Because it's still highly relevant.
Obviously, we aren't buying carbolic acid devices to ward off the flu anymore. But our source document explicitly maps this 1893 ruling directly onto the modern commercial landscape. Like, the ghost of Mrs. Carlyle haunts every modern marketing department.
It absolutely does. The Carlyle case is the exact reason why corporate legal teams and marketing departments are constantly at war.
Really?
Oh, yeah. The concept of creating a binding legal obligation through a public promise is everywhere in the digital age. Our source document provides a brilliant table of everyday scenarios where companies accidentally trap themselves. Let's walk through them.
Let's do it. The first scenario the source outlines is the publicly advertised product guarantee.
Right.
You see this constantly on social media. An advertisement says, "Our new indestructible backpack comes with a lifetime guarantee. We will repair or replace any tear at no cost, no questions asked."
Which is a bold claim.
To me as a consumer, that just sounds like a confident brand.
It sounds confident, but under the precedent set by Carlyle, that advertisement is a loaded legal gun.
Really?
It can easily be construed by a court as a unilateral offer to repair or replace the unit. The moment a customer buys that backpack, uses it, and it rips, they have performed the act.
Wow.
A binding contract is formed that very second. The company cannot suddenly say, oh, well, you didn't register the product within 30 days, or that guarantee only covers the zipper.
Because they didn't put those conditions in the original ad.
Exactly. There is no separate warranty agreement needed. The Instagram ad is the legally binding contract.
That's wild.
If the company tries to back out, they are in breach. This is why the source document strongly recommends that the best practice for any business is to frame a guarantee strictly as part of a comprehensive terms and conditions document.
So you cannot make a standalone, unconditional public promise without massive risk.
Yeah.
What about scenario 2 from the source? Customer loyalty and referral programs. You sign up for a new ride-sharing app or a food delivery service, and the banner on the homepage says, refer 3 friends who make a purchase and receive $100 cash back.
Again, this is a classic unilateral contract in the wild. The company is not asking you to promise that you will refer friends.
Right.
They are stating that if you do the act of referring 3 successful customers, they will pay you. Your obligation to the company is 0, but their obligation to you triggers the millisecond that 3rd friend completes their first order.
So if the company realizes their marketing campaign went viral and they are suddenly on the hook for like $10 million in referral bonuses, they can't just pull the plug and say promotion ended.
If you completed the action while the offer was still publicly valid, they are legally bound to pay you. They cannot retroactively cancel a unilateral contract after the performance has been completed. To protect themselves, companies must ensure that any promotional offer explicitly links to a separate set of rules governing eligibility, budget caps, and termination rights.
It is the exact same mechanism for sweepstakes and contests, right?
Ah.
Solve this complex coding puzzle and win a job interview and $10,000.
Absolutely. The winner's right to the prize crystallizes upon the successful completion of the task. If a company runs a contest, they have to meticulously detail the entry requirements, the judging criteria, and the exact nature of the prize in an official rules document.
Otherwise, a simple tweet announcing a contest becomes a binding guarantee to anyone who completes the steps.
Precisely.
So the takeaway from the 1890s is profound. Words, especially public words, are incredibly dangerous. You do not need a signature, a notary, or dense legal document to form a contract.
Not at all.
The second you perform the requested action, the trap snaps shut. The contract exists, completely bypassing all the formal paperwork we usually associate with the law.
It is a perfect demonstration of the law recognizing actions over formalities. But, this raises an essential question for us to explore.
What's that?
If a binding contract can be formed by a woman sitting in her London parlor using a flu remedy based on a newspaper clipping, what actually makes a contract?
Right. If we strip away the corporate letterheads and the signatures, what are the fundamental building blocks of these agreements?
Which transitions us perfectly to the second major piece of our source material.
Yes. We have this critical analysis report by an advocate named M. Usman Ali Khan.
And he took a magnifying glass to a legal infographic that was designed to teach the public about the sources of contract law and the basics of contracts, specifically looking at employment.
Khan's analysis is incredibly insightful because it highlights a major problem in how the public is educated about the law.
Right, it does. Educational materials, especially infographics, often try to simplify complex legal ecosystems into neat, tidy linear diagrams.
And Khan points out how this oversimplification leads to dangerous conceptual confusion.
Exactly. Let's look at his critique of the first panel of this infographic. Sources of contract law.
According to the report, the infographic lays out categories like commercial contracts, self-regulatory codes, sources, and specific laws.
Right.
And it arranges them in a flowing, linear sequence, as if one thing naturally leads to the next.
And Khan rightly dismantles this visual structure. The law does not work like a manufacturing assembly line.
You don't start with a generic source, add a specific law, and out pops a commercial contract.
No, not at all. Khan clarifies a fundamental misunderstanding the infographic creates. The infographic separates sources from specific laws, meaning statutes or legislation passed by a parliament or Congress.
Okay.
Khan emphasizes that specific laws are primary sources of contract law. You cannot sever them.
Let's make that concrete. If two tech companies agree to develop a piece of software together, the source of their contract isn't just the common law principles of offer and acceptance we learned from Carlo. It is simultaneously governed by specific statutory laws, like the Copyright Act or data privacy regulations. The statute is the source material.
Precisely. And Kahn also points out the infographic's heavy, somewhat misleading emphasis on self-regulatory codes.
These are things like industry-specific codes of conduct, right? Like, say, a set of ethical guidelines published by a National Association of Real Estate Agents.
Exactly. The infographic presents self-regulation as a foundational source, almost co-equal with actual law.
Which Kahn argues is muddying the waters for a beginner.
It does muddy the waters.
Ah.
Self-regulatory codes are vital. They heavily influence how courts might interpret standard industry practices or determine what is considered reasonable behavior in a dispute. But a self-regulatory code is not the same as a statutory law backed by the coercive power of the state.
Right, if you violate a self-regulatory code, you might get kicked out of an industry group. But if you violate a specific statutory law, you might face massive financial penalties or injunctions.
Blurring the lines between the two is legally dangerous.
But the most revealing part of Kahn's analysis, the part that I think will genuinely shock people, comes in the second panel of the infographic, where the focus shifts to the employment relationship.
Yes, the basics of contracts in employment.
The infographic defines the employer, the employed, and the contract of employment. And here is where Kahn highlights a fact that shatters the blueprint illusion we talked about at the beginning.
Right.
Kahn notes that the infographic correctly states that a valid, legally binding employment contract can be entirely verbal.
This is a fundamental concept that so many people, both workers and managers, completely misunderstand.
Yeah.
Imagine a restaurant owner is desperate for a chef. A cook walks in, they have a 5-minute conversation, they shake hands, and the owner says, "Great, you start Monday at $20 an hour."
Okay.
The moment they shake hands, an immediate legally binding common law contract of employment has been created.
Okay, I have to stop you there and push back on this.
You know,
If I verbally agree to a job and we shake on it, and that handshake is a fully binding contract, then why do human resources departments exist?
that's the million-dollar question.
Right. Why did I spend my entire first morning at my last job sitting in a sterile room signing 40 pages of documents? Why all the written details if the handshake was already the legal contract?
That is the exact tension Kahn's report clarifies, and it is a crucial distinction for everyone navigating a career. The contract itself, the core agreement to exchange your labor for their money, sprang into existence the moment the verbal agreement was reached.
Okay.
However, modern governments recognize that verbal contracts are notoriously difficult to enforce if a dispute arises. It turns into a he said, she said battle.
Right. If the chef says he was promised $25 an hour and the owner says it was $20, how does a judge decide?
To prevent that chaos, specific labor laws and statutes require employers to provide what are legally termed written details or written statement of particulars within a certain time frame after employment begins.
So the 40 pages of paperwork isn't the contract itself.
For the most part, no. The paperwork is primarily an exercise in statutory compliance and evidence gathering.
Interesting.
The law mandates that specific terms must be explicitly detailed in writing for transparency and worker protection. This includes things like itemized pay statements, specific formulas for holiday entitlements, pension enrollment details, sick pay rules, and notice periods for termination.
Right.
The employer is generating this massive stack of documents to prove to the government that they are complying with national labor laws and to provide undeniable written evidence of the specific terms if a dispute ever lands in front of a tribunal.
So the written document is basically just an elaborate, legally mandated receipt of the verbal reality.
In many structural ways, yes. It is the evidentiary trail of the substantive agreement. You might sign additional specific clauses within that paperwork, like a non-disclosure agreement or a non-compete clause, which are separate contractual terms.
But the core employment relationship existed before the ink dried. Before we move off Kahn's critical analysis, there is a fascinating nuance he brings up from the third panel of the infographic regarding who actually fights these battles in court.
Oh, yes.
It is the distinction between an advocate and a lawyer. I think most people use those terms totally interchangeably, like synonyms.
They do, and it is a very common point of confusion, especially depending on where you are in the world. The terminology varies wildly by jurisdiction.
Sure.
But Kahn notes that the infographic makes a useful, if simplified, distinction that serves as a good mental model for the public.
The infographic defines an advocate as a person who is trained in the law and who fights for you in court. And it defines a lawyer as a broader, more generalized role, a person who is qualified to give advice about the law and sometimes speak for people in court.
Right.
How does Kahn analyze this?
Kahn points out that while this is a simplification, it traces back to historical divisions in legal professions, most notably the split between barristers and solicitors in the United Kingdom and many Commonwealth nations.
Walk us through that split, because it helps clarify who you actually need when you have a legal problem.
Think of a lawyer in this broad sense, or a solicitor in the UK system as your general legal architect.
Okay.
If a massive corporation is going through a complex billion-dollar merger, they engage a law firm. These lawyers provide extensive corporate advice, they draft the hundreds of pages of merger agreements, they conduct due diligence, and they negotiate the terms behind closed doors.
Right.
They are masters of paperwork, strategy, and advisory work, but they rarely, if ever, step foot inside a courtroom.
They're the ones writing the blueprint.
Exactly. But let's say that merger suddenly faces a massive antitrust challenge from the government, and the entire deal goes to a high-stakes trial before a judge.
Then what?
At that point, the law firm might brief and hire a specific advocate or a barrister. This is a specialist whose entire career is dedicated to courtroom advocacy.
Oh, I see.
They are highly trained in the rules of evidence, cross-examination, and presenting complex, persuasive arguments directly to a judge or jury.
So they are the trial warriors.
Yes. Kahn notes this is a helpful distinction for the public because it highlights that legal expertise is highly compartmentalized.
That makes total sense. You do not necessarily want the brilliant introverted lawyer who drafted your complex tax structure to be the person performing theatrical cross-examinations in front of a jury.
Definitely not.
And you don't want the fiery courtroom advocate drafting the minutiae of your commercial lease. Understanding these roles helps you understand how the legal system actually operates in practice.
Absolutely.
Okay, so let's synthesize what we have learned so far. We have established two massive foundational ideas. First, from the Carlyle flu remedy case, we learned that a public promise can instantly become a binding contract the moment someone performs an action, completely bypassing negotiation.
Correct.
Second, from Kahn's infographic analysis, we learned that a simple handshake creates a binding employment contract, and the mountain of subsequent HR paperwork is largely just statutory compliance and evidence.
Which brings us to the inevitable explosive collision of these ideas.
Right.
We know actions matter. We know paperwork is often just a receipt. So what happens when you do have a meticulously crafted, signed, highly detailed, written contract, but the contract is a complete fiction?
This is where the legal reality gets truly wild. We are moving from the 1890s to the modern era. We are looking at a 2011 United Kingdom Supreme Court case that essentially ripped up the rulebook and sent shockwaves through the corporate world.
AutoCleanse Ltd v. Belcher.
Yes.
If Carlyle is the foundation of unilateral contracts, AutoCleanse is the modern earthquake that shattered the foundation of how courts view employment contracts.
Wow.
To understand the magnitude of this case, we have to understand the specific people involved. AutoCleanse was a company that provided car valeting services.
Essentially, they provided professional teams of car washers to luxury hotels, corporate fleets, and high-end car dealerships across the country.
And AutoCleanse had a very specific, deliberate way of structuring their workforce, right?
They did. They were extremely meticulous about their paperwork. Every single valet, including a man named Mr. Belcher, was required to sign a very detailed, comprehensive written contract before they could start washing cars.
Right.
And this contract explicitly, in bold black and white ink, labeled the valeters as self-employed independent contractors or subcontractors.
So legally speaking, the paper said they were not employees of AutoCleanse. They were independent business owners who just happened to be doing business with AutoCleanse.
And to legally bolster this classification and make it look ironclad, AutoCleanse included several very specific clauses in the contract.
And the most important, and ultimately the most fatal, was a substitution clause.
A substitution clause?
Yes. This clause explicitly stated that if a valeter didn't want to work on a given day or was unavailable, they had the absolute right to send a substitute, another person of their choosing, to wash the cars in their place.
Let's pause and dig into that. Why is a substitution clause so critical? Like, why would AutoCleanse go out of their way to put a clause in the contract saying, sure, send someone else to do the job?
Because the right to substitution is a fundamental hallmark of being an independent business. It is the difference between a contract of service and a contract for services.
Break that down for me.
Let's use an example. If I hire a local plumbing company to fix a burst pipe in my house, I am hiring them for a service. I do not care which specific plumber they send to my house as long as the person is competent and the pipe gets fixed.
Right, that is a commercial relationship.
But if I hire an employee to be my personal administrative assistant, I expect that specific person to show up to the office every day. I am contracting for their personal service.
I see. So by putting a substitution clause in the contract, AutoCleanse was trying to legally prove, look, we don't care who washes the cars. These Velites are independent plumbing companies, basically. They can send whoever they want.
Exactly. On paper, it looks perfectly clean. The blueprint shows a standard business-to-business relationship.
Right.
But here's the critical question. What was the actual reality on the ground for Mr. Belcher and his colleagues?
Right. From the source material, the reality was fundamentally different from the paperwork. The employment tribunal investigated what actually happened every day.
And what did they find?
The Valeters were paid on a piecework basis, meaning they didn't set their own rates. AutoCleanse told them they would get paid a specific amount per car they washed.
Okay.
Furthermore, they were required to wear uniforms supplied by AutoCleanse. They used specific chemical cleaning equipment provided by AutoCleanse. They received mandatory training from the company.
And most importantly, they operated under a high degree of daily direction and control imposed by AutoCleanse managers on site.
Right. And what about that all-important substitution clause? Did Mr. Belcher ever wake up, decide he wanted to go fishing, and send his cousin to wash cars at the luxury hotel?
Never. The tribunal found that the valuers were fully expected to perform the work personally, every single day. If they didn't show up, they were reprimanded.
Wow.
The substitution clause was purely theoretical. It was a legal fiction existing only on the paper they signed.
So we have a massive disconnect between the written contract and the physical reality. Historically, courts had a very, very hard time dealing with this.
We did. And it is important to understand why courts historically side with the paper.
Yes. Why is it so hard for a judge to just look at the situation and say, obviously, this guy is an employee?
It goes back to a foundational legal philosophy called the sanctity of contract, or freedom of contract.
Okay.
For centuries, the law has operated on the assumption that adults of sound mind should be free to make whatever commercial arrangements they want without the government interfering.
Right.
If a judge starts rewriting contracts because they think a deal is unfair, it creates massive uncertainty. Businesses wouldn't know if their agreements were actually binding until a judge reviewed them.
So the default position of the courts has always been, you signed it, you agreed to it, you are bound by it. We will not look behind the document.
Exactly.
But surely there were exceptions. What if the contract was a complete lie?
Before AutoCleanse, the prevailing legal approach for employment disputes was governed by a 2007 precedent called Consistent Group Limited v. Kalwak.
Okay.
Under the consistent group test, if a worker wanted a court to throw out a written contract and look at the reality, they had an incredibly high burden of proof. The worker had to prove that both parties, the employer and the worker, had a common intention to create a sham contract.
A sham contract, meaning they both knew it was a lie from the start.
Yes. Usually this standard was applied in cases where a company and a worker secretly conspired to misclassify the relationship specifically to evade paying income taxes or to bypass immigration laws.
Let me get this straight. Under that old rule, if Mr. Belcher wanted to prove he was an employee, he couldn't just show the judge his uniform and his manager's schedule. He would have to somehow prove that he and the AutoCleanse executives secretly conspired together to trick the government.
Exactly. And as you can imagine, that requirement is absurdly restrictive and almost impossible to prove in a normal employment scenario.
Yeah, the worker is almost never conspiring with the corporation.
Exactly. The reality is a massive inequality of bargaining power. A guy who just needs a job to feed his family isn't negotiating the nuances of substitution clauses. He's just signing the standard form, take it or leave a contract the company slides across the desk so he can start earning wages.
So the old law basically allowed companies to write whatever fictions they wanted into the contract, knowing the worker could never prove a mutual conspiracy. It was a perfect trap.
It was. Until the case reached the UK Supreme Court, and Lord Clark delivered a ruling that fundamentally changed employment law.
How did the Supreme Court dismantle this trap?
Lord Clark and the unanimous Supreme Court threw out the consistent group requirement to prove a mutual intent to create a sham. They realized the old rule ignored the reality of how jobs work.
Right.
Lord Clark introduced a new, devastatingly simple test. He said tribunals no longer need to look for a conspiracy. Instead, they must ask one question. What is the true agreement between the parties?
The true agreement, not the written agreement, not the signed document, the actual substance of the relationship.
Exactly. Lord Clark explained that employment tribunals should entirely disregard the express written terms of a contract if those terms do not reflect the reality of what was actually agreed and implemented in practice.
Wow.
He introduced a phrase that has become a cornerstone of modern labor law. He said a key indicator of an unreal, fictional, contractual term is when no one sensibly expects it to be implemented.
No one sensibly expects it. It is such a pragmatic human standard.
It really is. Looking at the AutoCleanse substitution clause, AutoCleanse management didn't actually expect Mr. Belcher to send a random, untrained stranger to wash a fleet of luxury cars. It would be an operational disaster.
Right. And Mr. Belcher didn't expect to have the freedom to act like a plumbing CEO and hire his own subcontractors.
Exactly. Therefore, the Supreme Court completely disregarded the substitution clause. They crossed it out.
They looked past the contractual labels of independent contractor.
They focused on the substantive reality. Mr. Belcher was integrated into the company's operational system, he provided personal service, and he was subject to managerial control. He was an employee.
You know, I love the analogy you used earlier when we were reviewing the notes. It perfectly encapsulates what the Supreme Court did here.
Yeah, it's like a boss handing you a script to read.
Right. They sit you down, hand you a piece of paper that says, "Congratulations, you are the independent CEO of MOP operations." You sign it. But then they hand you a mop, they tell you exactly which hallway to sweep, they yell at you if you're 5 minutes late, and they tell you that you are absolutely forbidden from letting your friend cover your shift. You are not a CEO. You are just sweeping the floor on their schedule.
Exactly. What AutoCleanse did was give the judge the power to rip up the CEO script and look at the mop.
Ripping up the script and looking at the mop, it is a profound shift from prioritizing form to prioritizing substance.
And AutoCleanse wasn't just a localized victory for a few car washers in 2011. It was the legal equivalent of splitting the atom. It released an energy that would soon collide with the biggest technological shift of the decade.
Because if a manual car washing business can't hide behind a fictional substitution clause, what happens when you scale that exact same legal fiction up to a multi-billion-dollar tech platform?
Exactly.
This brings us to the gig economy and the domino effect of misclassification. AutoCleanse fundamentally changed how the law views the power dynamic between massive Silicon Valley apps and individual workers.
The substantive approach, pioneered by Lord Clark in AutoCleanse, became the primary weapon in subsequent landmark cases against the gig economy, the most famous and perhaps the most consequential being Uber BV Aslam in 2021, again before the UK Supreme Court.
I think everyone listening has either taken an Uber, ordered food through a delivery app, or knows someone who drives for one. Walk us through how the AutoCleanse logic applied to Uber, because Uber's legal defense was formidable.
Uber's defense was essentially a highly sophisticated, digitized version of the AutoCleanse contract.
Okay.
Uber argued that they were not a transportation company at all. They argued they were merely a technology provider. They provided a software platform that acted as a booking agent, connecting independent, self-employed transportation business owners, the drivers, with passengers.
They said, we just make the software. The drivers are their own bosses running their own micro businesses.
Precisely. And every driver had to click "I agree" to a complex, digitally signed contract explicitly defining them as independent contractors.
No.
But the Supreme Court, channeling the spirit of AutoCleanse, refused to be blinded by the digital paperwork. They investigated the day-to-day reality of the driver's experience, and what they found was a far cry from independent business ownership.
But wait, I have a genuine question here.
Sure.
In the AutoCleanse case, there was a human manager physically standing in the parking lot, handing out uniforms, dictating the schedule, and yelling at people. In the Uber case, there is no human manager. There is no boss in the passenger seat. It is just an app pinging a phone. Does the law really see a piece of code as managerial control?
That was the exact philosophical defense the tech platforms tried to use. We can't be employers, we're just an algorithm. But the Supreme Court definitively answered yes.
Wow.
The court recognized that algorithmic management is a modern, pervasive, and incredibly intense form of control. In many ways, an algorithm is far more controlling than a human manager because it is omniscient and perfectly consistent.
How so?
Well, the court looked at the mechanisms of the app. The drivers faced penalties, including temporary lockouts or permanent deactivation, if their acceptance rate of rides dropped below a certain algorithmic threshold.
That is control.
Uber set the fares. The driver, unlike a true independent business owner, had absolutely no power to negotiate the price with the passenger.
That is control, too.
Uber dictated the route via their navigation system, and the drivers were strictly monitored and disciplined through the passenger rating system. The court proved that technology cannot be used as a shield to hide the true subordinate nature of the working relationship. The algorithm is the manager.
And we saw this same legal logic applied to food delivery platforms like Deliveroo and courier services, right? The courts consistently applied this purposive approach to look past the app's documentation.
The message from the judiciary is unequivocal. You cannot contract your way out of employment rights simply by using clever terminology and routing the instructions through a smartphone app.
So let's break down exactly what is at stake here. Why are companies willing to fight these battles all the way to the Supreme Court? Why do these classifications matter so much?
Money.
Right. In our source material, Khan's infographic analysis touched on contractual rights, and the framework paper gives us an incredibly detailed breakdown. We need to walk the listener through the 3 specific tiers of employment classification in the UK and the rights attached to them, because this is where the financial rubber meets the road.
The law generally recognizes 3 distinct classifications, or buckets, that a worker can fall into. Bucket 1 is the employee, Bucket 2 is the self-employed contractor, and Bucket 3, which is unique and crucial to the gig economy, is the worker.
Let's start with the top tier, the employee. What legally defines an employee, and what do they get in return?
An employee operates under a formal contract of employment. The defining legal characteristic here is a high degree of what the courts call mutuality of obligation.
Mutuality of obligation. Break that down for me.
It means there is a continuous reciprocal duty between the 2 parties. The employer is obligated to offer work, and the employee is obligated to accept it and perform it.
Okay.
If you work in an office, your boss expects you to be there Monday to Friday, and you expect them to provide you with tasks and a salary. Furthermore, employees are subject to significant control and direction over how they do their job, and they must perform the work personally. They cannot send a substitute.
And in return for giving up all that autonomy and submitting to control, what are their rights?
They get the gold standard, the full suite of statutory rights. This includes automatic enrollment in pension schemes, the guaranteed national minimum wage, paid holiday leave, sick pay, maternity and paternity rights, and critically, protection against unfair dismissal after a qualifying period of time.
What does unfair dismissal protection actually mean in practice?
It means that if you are an employee, the company cannot just fire you on a whim because the manager doesn't like your shoes. They must have a valid legal reason like redundancy, gross misconduct, or documented poor performance, and they must follow a fair, formal disciplinary process before terminating the contract. If they don't, you can sue them for significant compensation.
Okay, so that is the ultimate protective tier. Let's look at the complete opposite end of the spectrum. The self-employed contractor. This is what AutoCleanse and Uber claimed their workforce was.
Right. A self-employed contractor operates under a contract for services, not a contract of employment.
Okay.
Here, there is zero mutuality of obligation.
Meaning?
Think of a freelance graphic designer. A company offers them a project to design a logo. The designer has the absolute freedom to say, no, I'm too busy, or I don't like that price.
Right.
There is minimal control over how the work is done. The designer works from their own office, on their own laptop, on their own schedule, and crucially, they can generally provide a substitute to do the work if they want to outsource it.
And because they are truly independent, what rights do they have against the company hiring them?
Absolutely zero statutory employment rights. No pension, no minimum wage guarantee, no paid holidays, no sick pay, and zero protection from unfair dismissal. The contract can usually be terminated at any time according to its commercial terms.
Wow.
They are also completely responsible for calculating and paying their own income taxes. They take on the entrepreneurial risk of running a business, but they reap the reward of total flexibility and potentially higher profit margins.
Which makes total sense. If I hire that freelance designer, I don't expect to pay for their 2-week vacation to Italy. But what about this middle bucket? The worker status. This seems to be the specific battleground where the gig economy is fighting for its life.
The worker classification is a specific statutory creation designed by the UK government to protect people who fall into a vulnerable gray area. These are people who aren't quite full permanent employees, but who are definitely not independent businesses running their own affairs.
How does the law define them?
A worker still has a contract to perform services personally, meaning they generally cannot send a substitute, and they are subject to some level of control by the company. However, the mutuality of obligation is much lower or intermittent. They might only be obligated to follow the rules while they are actively performing a task.
This sounds exactly like the Uber driver reality.
Right.
When the drivers log on to the app, they have to do the work personally, they have to accept rides or get penalized, and the algorithm controls them. But they don't have to log on tomorrow if they decide they want to take the day off. The continuous obligation isn't there.
Exactly. They are subordinate and dependent on the platform for their income, but they have more flexibility than a traditional employee. Because of that vulnerability, the law grants them a set of core protections.
Like what?
Workers are legally entitled to the national minimum wage, paid holiday leave, and protection from unlawful wage deductions. However, they do not get the full suite of rights. Most notably, they do not get the right to claim unfair dismissal.
So let's look at the immense financial stakes here for a modern corporation. If you are a tech giant and you classify 100,000 drivers as self-employed contractors, you are saving billions of dollars by not paying holiday leave, not contributing to pensions, and not topping up wages when demand is low to meet the minimum wage.
Right.
But if the Supreme Court suddenly drops the auto-cleanse hammer, looks at the reality, and reclassifies all 100,000 of them as workers.
You are exposed to catastrophic business-ending financial liability. We are talking about massive class action back pay claims for years of unpaid holiday time, severe regulatory penalties, and a fundamental upending of the unit economics of your entire business model.
Wow.
Misclassifying a workforce to avoid costs is no longer just a clever legal loophole drafted by aggressive lawyers. It is an existential business risk.
Which brings us directly into the boardroom. Let's put the listener in the shoes of the corporate executives navigating this chaos. Imagine you are the CEO, the chief financial officer, or the general counsel of a massive company.
They must be sweating.
Right, because if we combine the accidental contracts of Carlyle with the destroyed contracts of AutoCleanse, the people running these companies must be having absolute nightmares trying to keep the business compliant.
They absolutely are. And this brings us to the final, incredibly complex layer of our source material. The corporate nightmare of accounting, tax, and governance.
Oh boy.
The source document highlights a massive, deeply confusing headache for corporate boards. The severe mismatch between different legal interpretations and financial reporting regimes.
Let's start with what the source calls the tax versus employment trap. This stems directly from the AutoCleanse jurisprudence. How can these two realities conflict? How can someone be two things at once?
It creates a bizarre, almost Kafkaesque reality for a business, because the specific criteria for determining employment status can sometimes differ slightly between an employment tribunal and the national tax authorities like Her Majesty's Revenue and Customs in the UK or the IRS in the US. A company can find itself trapped in a dual reality.
Walk me through a scenario.
Let's say an individual gig worker takes a company to an employment tribunal. The judge applies the AutoCleanse test, looks at the reality of the algorithmic control, and decrees that the individual is legally a worker. This means the company is legally obligated to pay them minimum wage and provide paid holiday time.
Okay, so the company accepts the ruling, adjusts their payroll, and starts paying the holiday pay.
But then the National Tax Authority conducts an audit of the exact same company and the exact same working arrangement. And the tax authority says, actually, under our specific rigid tax codes regarding entrepreneurial risk, we still consider this person to be a self-employed independent contractor.
Wait, so the company is legally forced by a judge to treat them like an employee for benefits, but the worker is forced by the government to treat themselves like an independent business for their taxes.
Exactly. It creates a schizophrenic compliance environment. The individual is left responsible for calculating and filing their own self-assessment income tax and national insurance contributions.
That's messy.
Meanwhile, the company's HR department has to navigate a payroll system that somehow accounts for generating statutory holiday pay without automatically deducting the standard pay-e-pay, as you earn income taxes that normally accompany employment benefits. It forces employers to navigate two separate, contradictory legal regimes simultaneously.
That sounds like an administrative disaster. But as bad as that is for the HR department, the source document points out an even bigger headache for the finance department, the accounting disconnect.
Yes.
And to understand this, we have to circle all the way back to our Victorian flu remedy from 1893. Let's talk about the clash between unilateral contracts and global accounting standards, specifically IFRS 15 and ASC 606.
We need to slow down here, because this is where legal theory and corporate finance collide. IFRS 15 and ASC 606 are the global accounting standards that govern revenue recognition.
What exactly is revenue recognition?
It is the set of rules that dictate exactly when a company is legally and ethically allowed to write down on their official financial statements that they have earned money. You can't just claim revenue whenever you feel like it.
Like historically, companies would claim future hypothetical money as current profits to make their stock price look better. Think of the Enron scandal.
Exactly. These rules exist to stop that. The golden rule of IFRS 15 is that revenue can only be recognized when control of the goods or services is definitively transferred to a customer.
That seems logical.
Yeah.
You sell a physical widget, the customer walks out of the store with the widget, you record the revenue on your balance sheet that day.
But here is where the ghost of Mrs. Carlisle throws a massive wrench into the machine. These strict accounting standards contain specific provisions that affect the very existence of a contract for accounting purposes.
Oh, wow.
Specifically, they state that a contract might not exist on the financial books if each party has a unilateral right to terminate the wholly unperformed contract without providing compensation.
Okay, that is dense. Unpack that for me with an example.
Let's say your marketing department decides to run a Carlisle-style unilateral offer to boost end-of-quarter sales. They launch a massive campaign. Buy our enterprise software today, and if it doesn't double your team's productivity in 30 days, we will refund your purchase completely and give you a $5,000 apology bonus.
A massive, bold promise designed to get signatures immediately.
The moment a customer buys it and downloads the software, under the contract law principles we learned from Carlisle, you have a binding legal obligation. You made a public promise, they perform the action of buying and installing it. The trap has snapped shut.
Right.
Your general counsel is sweating bullets because they know the company is legally on the hook for the refund and the $5,000 bonus if the software underperforms.
So the legal department says we owe this money.
But your chief financial officer looks at the rules of IFRS 15 and says, wait, the customer hasn't proven the software failed yet. The 30 days haven't passed. The conditions of the deal haven't fully crystallized. Under accounting standards, because there are massive contingencies and termination clauses built into this guarantee, we cannot recognize the initial sale as pure unrestricted revenue yet. Or we have to carve out a massive, complex liability provision on our balance sheet.
So you have a war room where the legal department says we have a binding legal contract and a massive liability, but the finance department says we can't put this money on the books properly yet because the accounting rules say the contract is conditional.
Precisely. It creates a massive disconnect between legal reality and financial reporting. A company might have created a legally binding obligation through a rogue marketing tweet, but their balance sheet doesn't accurately reflect the danger until the liability crystallizes, which might be too late. This is why the era of siloed corporate departments is over. Close, daily coordination between legal, finance, and marketing is no longer a best practice. It is essential for corporate survival.
So how does a modern company survive this minefield? Because it sounds like you can't run a marketing campaign without accidentally owing someone $1 million, and you can't hire a freelancer without accidentally owing them a pension. What is the actionable governance advice provided in our source document?
The source provides 3 very clear strategic recommendations for boards of directors and internal counsel to mitigate these risks. First, you must implement a mandatory pre-publication review process. This is specifically modeled to combat the Carlisle principle.
Essentially, step 1 is muzzle the marketing department, or at least supervise them very closely.
Exactly. The goal is to evaluate every single piece of public communication, every tweet, every banner ad, every promotional email, every influencer script, and ask one critical question. Is this a specific unconditional promise? If it is, the legal team must step in and transform that dangerous offer into a safe, aspirational puff.
How do you do that without ruining the ad?
You do it by adding clear qualifiers, limiting the scope of the claim, and anchoring the advertisement to a broader, highly detailed set of terms and conditions. You ensure that the ad explicitly states subject to T&Cs, and you make sure those T&Cs give the company the right to modify or withdraw the promotion. You never, ever make a standalone guarantee.
Okay, so that solves the accidental contract problem. What is step 2?
Step 2 addresses the auto-cleanse problem. Companies must conduct comprehensive recurring audits of all their non-traditional workforce arrangements. But critically, they cannot just review the paper contracts sitting in a filing cabinet. They must audit the physical reality.
They need to go down to the parking lot and see who's actually holding the mop.
Precisely. A cross-functional task force of HR, legal, and operational managers needs to go out into the field and ask the hard questions. Who is actually supplying the tools to these workers? Is our substitution clause ever actually utilized in the real world? How much day-to-day control are our middle managers or our software algorithms actually exerting over these people?
And if they don't match?
If the physical reality diverges from the contractual label, the company has to either restructure the relationship to ensure true independence or reclassify the workers and pay the associated costs. You cannot bury your head in the sand of the signed paperwork.
And the third and final recommendation.
Maintaining a dynamic compliance matrix. The law isn't static. It is a living, breathing thing that evolves from consistent group to AutoCleanse to Uber to whatever landmark case comes next year.
Right.
A company must constantly map their different operational roles against the most current legal interpretations and actively quantify the financial risk of misclassification. This needs to be a living document that guides workforce strategy at the board level.
That makes sense.
And ultimately, it is about fostering a culture of legal awareness. Every department head, from the creative director to the warehouse manager, needs to understand the practical implications of Carlyle and AutoCleanse so they can spot these risks in real time before they explode.
Wow. We have covered a massive amount of ground today. We started by looking at a blueprint, and we realized the building is what actually matters.
Yes.
We traveled back to a terrified London in 1893, looking at a carbolic acid flu remedy, and saw how a simple, boastful newspaper advertisement birthed the concept of the unilateral contract, proving that you can be legally bound to a massive debt simply because someone else performed an action, no signature required.
We then explored the nuances of cons analysis, learning that a binding employment contract can be formed entirely verbally over a simple handshake, with the mountain of subsequent HR paperwork merely serving as statutory receipts of that reality.
And then we hit the climax with AutoCleanse and the Uber cases. We witnessed the Supreme Court tear up written contracts that were full of fictions, like unused substitution clauses. We saw how the gig economy was forced to reckon with the true agreement doctrine, proving that managerial control, even when executed silently by an algorithm, completely supersedes whatever labels a company tries to force you to sign.
It's all connected.
The unifying theme of this entire deep dive is undeniable. The law increasingly cares about the substance of your physical reality, not the form of your paperwork.
It is a fundamental shift in legal philosophy. And frankly, for the individual listener, it is incredibly empowering.
Really? How so?
The next time you click I agree on a website terms of service or read a guaranteed marketing claim or take on a side hustle in the gig economy, you need to remember that your actual physical actions and the reality of the situation on the ground carry immense legal weight. You have rights and responsibilities that exist entirely off the page. The contract isn't just the paper. The contract is the behavior.
But before we go, I want to leave you with one final mind-bending concept to ponder. We have spent this entire deep dive learning that human judges will proudly ignore written contracts if the real-world behavior contradicts them. Judges look for the messy human reality. But if you look closely at the references section in our source document, you'll see a subtle nod to the future. The rise of smart contracts on the blockchain.
Ah, yes. The absolute bleeding edge of legal technology.
Exactly. For those who aren't familiar, smart contracts are essentially just pieces of computer code living on an immutable ledger. They execute automatically without any human intervention. If condition X happens in the real world, the code automatically transfers the money to person Y.
There's no judge to appeal to. The code just runs.
So what happens in a few years when the code is the law, but the human reality on the ground is entirely different? What happens when a smart contract executes a fundamentally unfair term automatically? Who does a human appeal to when there is no judge involved to rip up the paperwork because the contract mathematically enforces itself?
It is the ultimate collision course between the rigid binary logic of code and the nuanced, messy reality of human life. It is the exact opposite of the AutoCleanse ruling, and it is a legal battle we are only just beginning to see shape up.
It is fascinating. You know, we started by saying we usually expect a contract to be like a blueprint, but maybe that is the wrong metaphor entirely. A contract isn't a rigid architectural drawing. It is more like taking a patient's pulse. It gives you a reading of the relationship at one specific frozen moment in time. But if you want to know if the patient is actually healthy, If you want to know what the true agreement actually is, you have to stop staring at the medical chart, put down the paperwork, and actually observe the person breathing and living in front of you. The reality is the messy living action. Thank you for taking this deep dive with us today. Keep your eyes open, watch your actions, and always keep questioning the fine print.